My mother finished her testimony, smoothed her skirt, and folded her hands on the table like a woman who had already won. She had been talking for 22 minutes. Dates, figures, the name of every attorney who had ever touched my father's estate. Her voice never once cracked. I sat across the aisle and did not move. Then Judge Harlan Portis set down his pen. He looked at the documents in front of him for a long moment. And then, slowly, deliberately, he turned his eyes away from my mother and toward me. What my mother did not know was that the document she had just staked everything on had already been superseded. Quietly. Legally. In a file my father had prepared before she ever thought to open his desk drawer. I did not cry when they read me out of his will. I did not beg. I did not even unpack the box of his things they handed me at the door. Because what was already mine did not need me to fight for it. Before I continue, let me know where you are watching from in the comments below. Hit like and subscribe if you have ever been written off by the very people who were supposed to protect you. My father's name was Gerald Bennett, and he built things, not in the way people say that about men who inherit money and call themselves self-made. Gerald Bennett poured concrete on job sites at 22, read contracts at night, by a lamp he bought secondhand, and by 41 owned 3 commercial properties in Hartford and a development company that employed 61 people. He wore the same watch for 30 years. He drove a sensible car. He never once mentioned his net worth at dinner, and I never once heard him use the word legacy without meaning it. I am Whitney Bennett. I am 32 years old. I am a real estate attorney at a small firm in Glastonbury, Connecticut, and I learned everything I know about property law from watching my father read documents that other men handed him to sign without reading. He taught me that a contract is only as honest as the person who drafted it. He taught me to read every line. He taught me that the most dangerous sentence in any legal document is the one that sounds the most reasonable. I did not grow up poor. I want to be clear about that, because this story is not about poverty. It is about something quieter and, I think, more corrosive. It is about being the child in a family who is never quite chosen. My brother Caleb is 38. He is 6 years older than me. Broad-shouldered, easy with a laugh, and he has my mother's eyes and my mother's instinct for knowing which way a room is tilting before anyone else does. Growing up, Caleb got the car at 16. Caleb got the college tuition without an application process. Caleb got the calls on Sunday, the spot at the head of the table at Thanksgiving, the quiet conversations in my father's study that stopped when I walked past the door. I got good grades and learned not to knock. My mother, Diane Bennett, is 61. She is the kind of woman who remembers every slight and files it somewhere behind her eyes where it collects interest. She was not cruel to me the way people imagine cruelty. No screaming, no locked doors. It was more precise than that. A comment about my dress at Easter. A sigh when I mentioned a case I had won. The way she would ask Caleb for his opinion on something my father had just asked me. Small calibrations over many years that added up to a single clear message. You are here, but you are not quite ours. I used to think I was imagining it. I stopped thinking that when I was 27 and passed the Connecticut bar exam on my first attempt. I called home that evening. My mother said, "Well, that's a relief, Caleb," who had failed his real estate licensing exam twice, got a dinner at the country club. I did not bring it up. I learned early that bringing things up in my family was treated as a character flaw. My father was different with me, though. Not loudly. Gerald Bennett was not a loud man about anything. But he would appear in the doorway of wherever I was working, and just stand there for a moment, watching me read, and sometimes he would say something like, "You've got a good eye, Whit. Don't let anyone convince you otherwise." It was not much, but it was consistent, and from him, consistent meant everything. He started his own company, Bennett Commercial Properties, in 1991. By the time I passed the bar, its portfolio had grown to 11 properties across 3 counties and was valued conservatively at just over $4 million. The flagship asset was a 6-story mixed-use building on Asylum Street in Hartford. Retail on the ground floor, office space above, fully leased, generating reliable income every single month. My father called it the building that taught him patience. He had bought it distressed in 2003, spent 4 years stabilizing it, and never sold. He loved that building the way some men love boats. I knew the property inside out. I had reviewed 2 lease renewals for him at his request, drafted an easement agreement for the parking structure adjacent to it, and once spent a Saturday afternoon walking every floor with him while he pointed out things he wanted to eventually renovate. He told me that afternoon that he had always imagined his grandchildren might work in one of those offices someday. I was the only one of his children who had ever set foot in it professionally. Caleb worked in sales for a medical device company. He was not bad at it, but he had no interest in the properties, no understanding of the legal structures that held them together, and, as I would later confirm in discovery, no awareness of what his own signature on a document actually meant until it was far too late to take it back. My father had a heart attack on a Tuesday morning in March. He was at his desk. His assistant found him at 9:15. He was gone before the ambulance arrived. He was 64 years old, and I had spoken to him 4 days earlier about a boundary dispute on one of his smaller properties in Wethersfield. He had laughed at something, I said. I cannot remember what it was now, and that bothers me more than I expected it to. I drove to Hartford in the rain and sat in a hospital corridor that smelled like floor cleaner and someone else's grief, and my mother walked past me twice without stopping. That was the beginning. My father was buried on a Friday, beneath a sky the color of old pewter, in a cemetery on the east side of Hartford, where his own parents were interred 40 feet away. There were 112 people at the service. I counted because I needed something to do with my hands and my eyes that was not looking at my mother's face. Business associates, neighbors from the house I grew up in, men who had poured concrete with him in the early years and were now gray-haired and soft-spoken, a few of his tenants who came without being asked. The pastor spoke for 18 minutes. Caleb gave a eulogy that was mostly about himself. My mother sat in the front row in a black wool coat and received condolences with the composed efficiency of someone who had been rehearsing. I was not asked to speak. I found out 3 days before the service, when I called to ask about the program. My mother told me Caleb would be handling the remarks. She said it in the tone she reserved for logistical information, the same tone she used to tell me the caterer had been confirmed or the florist had changed the arrangement. Not cruel, just decided. The kind of sentence that arrives already finished, with no space left for a response. I said, okay. I drove 4 hours from Glastonbury. I sat in the second row. The house on Farmington Avenue had been my parents' home for 26 years. It was a colonial. 5 bedrooms, a back porch my father had rebuilt himself one summer, a kitchen that smelled like coffee and wood polish. I had not lived there since college, but it had always felt like the fixed point, the place that did not move when everything else did. The reception was held there after the burial. By 4 o'clock, the living room was full of people eating small sandwiches and saying the things people say, and I stood near the window with a cup of tea that had gone cold and watched my mother work the room. With a fluency I had always found slightly unsettling. She knew everyone's name. She remembered their children. She touched arms and leaned in close and laughed at the right moments, and no one watching her would have guessed she had buried her husband 6 hours earlier. Caleb found me near the bookcase at 5:30 and said, "Mom wants to do the will reading next Saturday. Just family. Keep it simple," I said. "That's fast," he shrugged. "No point dragging it out." I nodded and looked back at the window. The will reading was held at the offices of Whitmore and Associates on Trumbull Street. The family's attorney of record for 11 years, a soft-spoken man named Douglas Whitmore, who had drafted the original Bennett estate plan and revised it twice that I knew of. My mother had arranged it. She had also, I noticed when I arrived, arranged the seating. Herself and Caleb on one side of the conference table, a single chair on the other side for me, with no legal representation of my own present. I should have caught that. I was a lawyer. I knew what asymmetric seating at an estate reading meant. I sat down anyway. Douglas Whitmore read the document in a measured voice without looking up more than twice. The estate, per the will dated 14 months prior, was to be distributed as follows: the family residence on Farmington Avenue and its contents to Diane Bennett outright. The investment accounts, totaling approximately $1.4 million, split 70% to Diane and 30% to Caleb. Bennett Commercial Properties, including all 11 assets, transferred in full to a newly formed LLC to be jointly controlled by Diane and Caleb Bennett. With no provision for Whitney Ann Bennett, he stopped reading. The room was quiet except for the sound of a truck passing on Trumbull Street outside. I looked at my mother. She was looking at her hands. Caleb was looking at the window. Neither of them looked at me. I said, "Can I see the document?" Douglas Whitmore slid it across the table without comment. I read it, all of it. Every clause, every schedule, every signature block. My father's signature was on the last page, above a notary stamp dated 13 months ago. The signature looked like his. The paper looked standard, the notary seal looked valid, everything about it looked exactly right. I set it back on the table. "Thank you," I said. I picked up my bag. I stood up. My mother finally looked at me. Just for a second. Something moved across her face that was not quite guilt and not quite satisfaction. Something in between, something I had seen before in smaller doses over 32 years, and now understood completely. I walked out of the office and down the elevator, and through the lobby and out onto Trumbull Street, where the March wind came off the river and hit me in the face, and I stood on the sidewalk for a moment and breathed. I did not cry. I did not call anyone. I did not go back inside. I walked 2 blocks to my car, sat in the driver's seat, and opened the Notes app on my phone. I typed 4 words, "Find the other document," because I was a real estate attorney. And I had just read a will drafted by a man I knew, in a style I recognized, with a signature I had seen on 100 documents. And something in the back of my professional mind, underneath all the grief and the shock and the cold weight of being erased by your own mother, was sending up a quiet, steady signal. Something in that document was wrong. I could not name it yet. But I had learned from my father to trust the instinct that fires before the logic catches up. He had told me once, standing in that building on Asylum Street, that the deals that cost him the most were the ones where he had felt something was off and talked himself out of it. I started the car. I drove back to Glastonbury in the dark. I did not unpack the box of my father's things they had handed me on the way out. His watch, a photograph, 2 pens, and a small leather notebook I had never seen before, not because I was too sad to look at them, because I needed to think before I touched anything. I did not sleep that night. Not the restless, grief-soaked sleeplessness of someone who has lost a parent. Though that was there too, underneath everything, like a low note held too long. This was different. This was the sleeplessness of a lawyer who has read a document that doesn't add up and cannot stop her mind from running the numbers. I sat at my kitchen table in Glastonbury with a yellow legal pad and a cold cup of coffee, and I wrote down every detail I could remember from the will Douglas Whitmore had read. The date. The notary's name, Margaret L. Folds, commission expires 04/2026. The clause structure. The specific language around the LLC formation, which had struck me as unusually clean for a document that was supposedly drafted 14 months ago, when my father had been healthy and not, as far as I knew, in any particular hurry to restructure his estate. I wrote down what I remembered of the signature. My father had a distinctive hand. He had learned to sign his name on contracts in his 20s, when handshakes still preceded paperwork, and he had told me once that a signature was the one mark a man made that had to mean something. His G curved high and broke away sharply to the right. His B was closed at both loops. He had signed his name the same way for 40 years. And I had seen it on leases, on easement agreements, on the boundary dispute correspondence we had exchanged just 4 days before he died. The signature on that will had the right shape. But the pressure was wrong. I know how that sounds. I am not a handwriting expert. I had no training in forensic document examination, but I had reviewed 11 documents bearing my father's signature in the previous 18 months alone, and there was something about the way the ink sat on that page, lighter at the start of the G, heavier at the tail of the B, that did not match the man I knew, who bore down when he signed, always, as if he was making a permanent mark on the world and wanted to be sure it held. It could have been nothing. He had been 64. People's hands change, but I wrote it down anyway. I turned to the leather notebook from the box. It was small, burgundy, the kind sold at office supply stores. My father's initials were not on it. There was no label, no date on the cover. I opened it to the first page and found what appeared to be a series of notes in his handwriting, property addresses, phone numbers, a few names I didn't recognize, dollar figures without context. Standard enough for a man who ran a property company and thought on paper. I turned pages slowly. On the 14th page, I found a name that stopped me, Hargrove and Pelletier, LLP. An address on Asylum Street, 3 blocks from the building he loved, a phone number, and below it, in my father's handwriting, underlined once. Independent. I stared at that line for a long time. W. My name is Whitney. My brother's name is Caleb. My mother goes by Diane, never D. Independent. In a notebook my mother had apparently not thought worth keeping, mixed in with a box of items they had considered disposable enough to hand me on the way out of a building where they had just legally erased me. I closed the notebook. I set it flat on the table. I placed my hand on top of it and sat very still for a moment. Then I picked up my phone and searched Hargrove and Pelletier LLP. It was a small estate planning firm. 2 partners, 3 associates, offices on Asylum Street in Hartford since 2009. No connection to Whitmore and Associates that I could find. No overlap in client base as far as public records showed. A clean, quiet, professional website with no indication of anything remarkable about them at all. I called them the next morning at 8:53, before my first client call. From my car in the parking lot of my office building, a woman answered on the second ring. I told her my name. I told her my father's name. I told her he had passed 11 days ago and that I had found their firm's name in his personal notebook, and that I was calling to understand whether they had any record of a professional relationship with Gerald Bennett. There was a pause on the other end. Not the pause of someone who doesn't know the answer, the pause of someone deciding how much of it to give. She said, "Ms. Bennett, I'm going to ask you to hold for just one moment." I held for 4 minutes. I watched a man walk into my office building, carrying a coffee and a folded newspaper. I watched a pigeon land on the curb and walk in a small circle and leave. A man came on the line. His voice was measured and careful, the voice of someone who chose words the way my father chose contractors. Slowly, after consideration, he said, "Ms. Bennett, my name is Richard Pelletier. I'm glad you called. We've been trying to determine the right way to reach you." I said. "Why?" he said. "Because your father left instructions and one of them concerned you, specifically." The wind moved through the parking lot and rocked my car almost imperceptibly, and I gripped my phone with both hands and said nothing. Because I had learned from my father that silence in a negotiation is not weakness. It is the space you hold open for the other person to fill with the truth. Richard Pelletier filled it. "Mr. Bennett came to us approximately 5 weeks before his death," he said. "He engaged our firm independently of his existing estate counsel. He was specific about that. He drafted a codicil to his existing will, a supplement that, under Connecticut law, supersedes any conflicting provisions in the original document. It was executed in our offices, witnessed by 2 attorneys, and notarized by our senior paralegal. It has been in our secure document storage since the day he signed it. I did not move. He told us," Richard Pelletier continued, "that he wanted to ensure the document reached you directly, and only you, in the event that you came looking. He said, and I am reading from our intake notes here, that his daughter would know to look if something felt wrong." The parking lot blurred slightly at the edges. My father had known. He had known what my mother was capable of. He had known what would happen after he was gone. And 3 weeks before his heart gave out at his desk on a Tuesday morning, in March, he had sat across from a lawyer he had chosen himself. Independent, he had written, underlined, and he had made sure I would not be left with nothing. He had not warned me. He had not told me. He had simply prepared, quietly and completely, the way he did everything, and then he had trusted me to be the kind of person who would not walk away without asking one more question. I sat in that parking lot for 11 minutes after I hung up the phone. Then I went inside, canceled my 9 o'clock, and began building the case. I want to tell you about the codicil, because most people do not know what one is until they need one, and by then it is usually too late. A codicil is a legal amendment to an existing will. It does not replace the entire document. It modifies specific provisions, adds new instructions, or overrides clauses the testator has decided no longer reflect his intentions. Under Connecticut law, a validly executed codicil takes precedence over any conflicting language in the original will. It requires the same formalities as the will itself. The testator's signature, 2 witnesses, a notary. When both documents exist, the codicil wins. My father had known this. Of course he had. He had spent 40 years reading contracts. I drove to Hartford on a Thursday morning, parked on Asylum Street, 2 blocks from the building he had loved, and walked into the offices of Hargrove and Pelletier at 10 o'clock. Richard Pelletier met me in the lobby himself. He was a compact man in his late 50s, with wire-rimmed glasses and the unhurried manner of someone who had spent a career delivering consequential news and had learned that the most important thing he could offer in those moments was steadiness. He shook my hand. He said he was sorry about my father. He meant it. I could tell because he did not say anything else after it, did not fill the space with qualifications or pivot immediately to business. He just let it sit there for a moment, the way you do when something is true and sufficient on its own. Then he led me to a conference room and set a folder on the table. The codicil was 4 pages. My father's handwriting was not in it, It had been drafted by Pelletier's associate from Gerald's instructions. But his signature was on the last page, above the signatures of two witnessing attorneys and the notary stamp of a woman named Carol Innes. Commission valid, date confirmed. February 19th, 3 weeks and 4 days before my father's heart stopped at his desk. I read all 4 pages without speaking. The codicil made 3 changes to the existing will. The first, the family residence on Farmington Avenue, was removed from outright transfer to Diane Bennett and placed instead into a life estate, meaning my mother could live there until her death or voluntary departure, but could not sell it, encumber it, or transfer it. Upon her vacating, ownership would pass to me. The second, the investment accounts were to be redistributed. Diane's share was reduced to 40%. Caleb's 30% remained. The remaining 30%, approximately $420,000, was directed to Whitney Ann Bennett outright, no conditions, no trustee, no delay. The third, and the one that made me set the document down and press both palms flat on the table and breathe through my nose for a moment. Bennett Commercial Properties was not to be transferred to the LLC. My mother and brother had already begun operating. The entire portfolio, all 11 properties, including the building on Asylum Street, was to be placed in a trust. The trust's sole beneficiary was Whitney Ann Bennett. The trust's administrator, per my father's specific written instruction, was to be an independent fiduciary, not a family member, and attached to the codicil as Exhibit A was a letter in my father's own handwriting, 2 pages addressed to me. Richard Pelletier slid a separate envelope across the table. He said, "He asked that you read this privately. We'll step out." I waited until the door clicked shut. The letter began, "Whitney, if you are reading this, you found the notebook. I knew you would. You always read the fine print. I will not give you every word of that letter. Some of it belongs only to me, to the daughter who counted herself out of the front row at his funeral and sat in the second one with cold tea and did not make a sound. Some of it was practical. Instructions, names, a phone number for a forensic document examiner in New Haven, whom my father had apparently consulted before he died. Some of it was an explanation, careful and detailed, of why he had not told me what he was doing. He had been afraid, he wrote, that if I knew, I would try to confront it directly. He knew me. He knew I would want to walk into that house on Farmington Avenue and lay the facts on the table and demand a reasonable outcome, because that was how I operated. Directly, professionally, without drama. And he knew, with the certainty of a man who had been married to Diane Bennett for 37 years, that a direct confrontation would give her time to prepare, to maneuver, to find a way to complicate or contest what he had set in motion. So he had said nothing. He had simply built the architecture and trusted me to walk into it when I needed to. Near the end of the letter, he wrote, "The building on Asylum Street is yours. It has been yours in my mind for a long time. You are the only one of my children who ever understood what it cost and what it was worth. I am sorry I did not say that out loud while I had the chance. I am saying it now." I folded the letter and put it in my bag. I sat in that conference room for a few minutes after, looking at the window, at the gray Hartford sky above the roofline across the street, at the ordinary Tuesday morning traffic moving past on Asylum Street 3 floors below. Then I opened my bag and took out a legal pad. I had 4 things to do first. Retain Richard Pelletier's firm as co-counsel. They had drafted the codicil, they had witnessed it, and they had records going back to the day my father walked in. Their file was clean and their documentation was airtight. Second, contact the forensic document examiner my father had named in the letter. A woman named Dr. Sandra Okafor at a firm in New Haven. My father had already spoken to her. She knew the context. She was expecting to hear from someone eventually. Third, file a motion to reopen the estate proceeding and submit the codicil for judicial recognition. Fourth, and most carefully, do nothing visible. No calls to my mother, no messages to Caleb, no indication, from the outside, that anything had changed since I walked out of Douglas Whitmore's conference room on Trumbull Street with a box of my father's things and an expression that could be read as defeated because I needed them to keep going. I needed them to keep operating that LLC, keep spending from those accounts, keep presenting the forged will as the operative document. Because every day they did, they were building a case against themselves that I would not have to construct from scratch. My father had written near the very end of the letter, "Be patient, Whit. Patience is not the same as acceptance." It never was. I drove back to Glastonbury with the codicil in a sealed envelope on the passenger seat and the letter folded in my bag. And I thought about the building on Asylum Street and the way my father had walked every floor with me that Saturday afternoon, pointing at things he wanted to fix, talking about grandchildren in offices, and I understood for the first time that he had not been imagining a future abstractly. He had been imagining it with me in it. I had 4 months before the estate court's procedural deadline. 4 months to build something my mother could not dismantle, could not charm her way around, could not file a counter motion against fast enough to matter. I turned onto the highway and set my cruise control and let the flat gray Connecticut landscape move past the windows. And for the first time since I had stood on Trumbull Street in the March wind, with a cold certainty settling into my chest, I felt something shift, not relief, not yet. But the particular steadiness that comes when you stop waiting for someone to hand you justice and realize you already have everything you need to build it yourself. The thing about waiting is that it requires you to perform a version of yourself that does not exist. For 4 months after I left Richard Pelletier's office with that envelope on my passenger seat, I had to be Whitney Bennett, who had accepted her father's will. Whitney Bennett, who had been quietly devastated but was moving on with dignity. Whitney Bennett, who was not, at that very moment, working with a co-counsel, a forensic document examiner, and a motion that was 12 pages long and growing. It was not easy. But I had grown up in a family that required performance, and I was better at it than any of them knew. My mother called me 6 weeks after the will reading. It was a Sunday afternoon in late April, and I was at my kitchen table reviewing Dr. Okafor's preliminary findings when my phone lit up with her name. I let it ring twice, long enough to seem natural, then answered. She asked how I was. I said fine. She said she had been thinking about me. I said that was kind. She mentioned the weather in Hartford, a neighbor's new dog, a problem with the gutters on Farmington Avenue that a contractor had quoted at $4,000. Then she said, "We've been going through your father's business files, Caleb and I. There are some documents with your name on them, correspondence, a few lease reviews you apparently did for him. We'll need you to sign a release, confirming that any professional work you performed for Bennett Commercial Properties was done informally, without a retainer agreement, and that you have no claim to compensation or interest in those files." I wrote the word release on the top corner of my legal pad and drew a box around it. I said, "Send it over and I'll take a look," she said. "It's straightforward. It shouldn't need more than a glance," I said. "I'm sure. I'll look it over when I get it." There was a brief pause, the kind that meant she had expected less resistance and was recalibrating. "I'll have Douglas send it this week," she said. "That's fine," I said. "How is Caleb?" We talked for 4 more minutes about nothing. I made the appropriate sounds. When I hung up, I sat very still for a moment, then picked up my phone again and texted Richard Pelletier. "They're going to send a release informal work on BCP files. Do not respond until we speak," he replied within the minute. "Understood. This is good. Let them send it." It was good, because a release request meant they were worried. It meant someone, my mother, or Douglas Whitmore, or Caleb with his real estate licensing exam instincts, had looked at the work I had done for my father, and understood that a daughter who was also a licensed attorney and had performed documented legal work on estate assets had a potential basis for a claim they had not fully accounted for. They were trying to close a door. They did not know the door they actually needed to worry about was already open. 3 blocks from the building my father had left me, in a file cabinet at Hargrove and Pelletier. The release arrived by email on a Wednesday. It was 3 pages. The language was aggressive, in the way that documents drafted out of fear tend to be aggressive, overclaiming, overdefining, attempting to foreclose interpretations that no one would have thought to make unless the person drafting it was trying to hide something. I read it twice, forwarded it to Pelletier with 4 annotations, and did not sign it. I did not respond to Douglas Whitmore's follow-up email either. 3 weeks later, Caleb Dell showed up at my office. I was between client meetings when my assistant knocked and said my brother was in the lobby without an appointment. I told her to give me 5 minutes, straightened the files on my desk, and went out to meet him. He was standing near the reception desk in a dark coat, holding his phone with both hands the way people do when they need something to do with their hands. He was heavier than I remembered from the funeral. His jaw was set in the way it got when he was working himself up to something. I said, "Caleb," he said, "can we talk somewhere private?" We went to a small conference room at the end of the hall. I offered him water. He said no. We sat down on opposite sides of the table, and he put his phone face down between us like it was evidence. He said, "You didn't sign the release," I said. "No," he said, "Whitney, this isn't complicated. You did some informal work for Dad. That's it. There's no claim there. Douglas reviewed it. Mom reviewed it. It's clean." I looked at him. He had our mother's eyes. I had always thought, that particular shade of gray-green that shifted depending on what it needed from you. Right now, it needed me to agree. I said, "If it's clean, the release shouldn't matter." He leaned forward. "It matters because we're trying to settle the estate efficiently, and you are the only outstanding piece. Every other aspect is resolved. We just need this one thing from you," I said. "I'll have my attorney review it." Something moved through his expression. Not quite surprise. More like a recalibration, the same one I had heard in my mother's voice on the phone. They had both assumed, I realized, that I would be easier than this. That the woman who had sat quietly, in the second row, at her father's funeral, and walked out of a conference room without raising her voice, was the woman they would be dealing with indefinitely. They had mistaken composure for surrender. Caleb said, "You have an attorney?" I said, "I am an attorney, Caleb. I have several colleagues." He sat back, picked up his phone, set it down again, then he said, "And I want you to remember this moment because it mattered later. Mom is not going to let this drag out. She has plans for the Asylum Street property. There's a developer interested. It's a significant offer. If you create problems, you're going to cost everyone, including yourself, a real opportunity." I looked at him for a long moment. The Asylum Street property. The building my father had walked me through on a Saturday afternoon and talked about grandchildren in offices. The building he had written, in a letter I kept in a locked drawer at home, was mine in his mind for a long time. My mother had a developer. She was planning to sell it. I felt something move through my chest that was cold and very clear. Not anger. Anger would have been easier. This was something more structural. The kind of feeling that doesn't make you want to raise your voice. The kind that makes you want to go back to your desk, open your laptop, and work faster. I said, "Tell Mom I'll be in touch." Caleb left without shaking my hand. I went back to my office, closed the door, and called Richard Pelletier. I said, "They're moving toward a sale on Asylum Street. How close are we to filing?" He said, 2 weeks. Dr. Okafor submitted her final report this morning. I said, "Move it up." Dr. Sandra Okafor had been examining question documents for 23 years. She had testified in federal court, in state court, in arbitration proceedings and administrative hearings across 6 states. She had examined ransom notes, altered contracts, disputed signatures on insurance policies worth 9 figures, and a forged deed that had held up in probate for 11 years before someone thought to look closely enough. She was not a dramatic woman. She did not use words like damning or conclusive in casual conversation. She used words like inconsistent and statistically improbable and outside the range of natural variation, and she said them in a tone so flat and precise that they landed harder than drama ever could. She had examined 6 documents bearing my father's authenticated signature: leases, the boundary dispute correspondence, an amendment to a parking easement, and she had compared them against the signature on the will. Douglas Whitmore had read in his conference room on Trumbull Street. Her final report was 41 pages. I read all of it. The executive summary was 2 paragraphs. The second paragraph contained one sentence that I read 4 times, sitting at my kitchen table at 11:30 at night with the lamp on and the rest of the house dark. Based on comprehensive analysis of stroke pressure, pen lift patterns, connecting strokes, and proportional relationships between letter forms, it is the opinion of this examiner that the signature purported to be that of Gerald M. Bennett on the document dated 14 months prior to his death was not produced by the same individual whose authenticated signatures are contained in the reference set. Not produced by the same individual. My father had not signed that will. I sat with that sentence for a long time. I had suspected it since the night I sat at my kitchen table with a yellow legal pad and a cold cup of coffee and wrote down everything I remembered about the pressure of his pen. I had built 4 months of careful, quiet work on the foundation of that suspicion. But suspicion and confirmation are different things, and I want to be honest about what it felt like to have it confirmed in 41 pages of forensic analysis. It felt like grief and fury arriving at exactly the same moment and finding they had to share the same space. My father had not abandoned me. He had been forged. I called Richard Pelletier at 7 the next morning and told him to file. The motion to reopen the estate proceeding was submitted to Hartford Probate Court on a Thursday afternoon in late June. It was accompanied by the codicil, the Hargrove and Pelletier file documentation, Dr. Okafor's full report, and a 14-page memorandum of law that Richard's associate had drafted, and I had reviewed 3 times. We also filed a separate complaint with the Connecticut Statewide Grievance Committee regarding Douglas Whitmore's role in presenting a potentially forged document to the court. We did not notify my mother in advance. She found out on a Friday morning when the court's notice arrived at the Farmington Avenue house by certified mail. I know this because Caleb called me at 9:47 that morning. I did not answer. He called again at 10:15. I did not answer. My mother called at 10:52. I did not answer. At 11:30, I received an email from Douglas Whitmore requesting an urgent call to discuss a potential resolution before matters escalate further. I forwarded it to Pelletier with one line: "Do not engage, let them sit with it." What followed was 6 weeks that I can only describe as a controlled unraveling. My mother, through Douglas Whitmore, made 3 settlement overtures. The first offered me the 30% of investment accounts my father's codicil had designated in exchange for dropping the challenge to the will and releasing all claims against Bennett Commercial Properties. The second added a cash payment of $200,000 and a right of first refusal if the Asylum Street property was ever sold. The third was more desperate: a 50% interest in the property company, joint control with Caleb, and a formal apology letter from my mother, notarized. Each offer told me something. The progression told me everything. They knew the signature would not survive scrutiny. They were trying to buy a version of events where it never had to be examined in open court. I declined all 3 through Pelletier, without comment. Meanwhile, my mother was doing what my mother did when she was cornered. She was talking. I heard it first from my father's sister, Aunt Roberta, who called me on a Tuesday evening and said, carefully, that she had been hearing some things. That Diane had told several family members I had become erratic since my father's death. That I was struggling emotionally, that my grief had manifested in a way that was, as my mother apparently phrased it, concerning to everyone who loves her. Aunt Roberta's voice, when she told me this, had the particular careful quality of a woman who did not believe what she was repeating but felt obligated to pass it along. I thanked her. I told her I was fine. I told her she would understand everything in due course. The following week, I learned from a colleague whose firm occasionally overlapped with Whitmore and Associates that there had been a quiet inquiry, informal, nothing documented, about whether I had ever had any professional disciplinary issues. Someone had called the Bar Association. Someone had asked about complaints. There were none. There had never been any. I had practiced for 7 years without a single client grievance, a single ethics inquiry, a single late filing, but I noted it. I noted everything, because here is what my mother did not understand about the kind of quiet she had mistaken for weakness. It was not the quiet of someone who had given up. It was the quiet of someone who was building something load-bearing, piece by piece, in a space she could not see, and who understood that the moment you announce what you are doing is the moment the other side starts finding ways to dismantle it. I had learned that from my father, too. He had bought the Asylum Street building distressed, when everyone else looked at it and saw a liability. He had spent 4 years stabilizing it while people who knew better told him he was overextended. He had never once, in those 4 years, held a press conference about his plans. He had just kept going, quietly, until the building was the most valuable asset in his portfolio. I kept going. In the 7th week after we filed, I received a call from Pelletier on a Wednesday afternoon. He said, "The court has set a hearing date," he said, "Judge Harlan Portis. Hartford probate. 4 weeks from Thursday," he said, "Whitney. We are ready." I wrote the date on my legal pad. I drew a box around it. Then I set the pad down and looked out my office window at the parking lot below, at the ordinary Wednesday afternoon traffic, at the pigeons walking their small, determined circles on the curb. 4 weeks. I thought about my mother smoothing her skirt in that conference room on Trumbull Street. I thought about Caleb setting his phone face down on the table like evidence. I thought about the developer they had found for the Asylum Street building, and the plans they had made, and the future they had constructed on the foundation of a document that a forensic examiner in New Haven had spent 41 pages explaining was not my father's. I thought about my father sitting across from Richard Pelletier on a February afternoon, 3 weeks before his heart stopped, signing his name the way he always signed it, bearing down, making a permanent mark, the way he had done everything. I had 4 weeks. I went back to work. Connecticut probate proceedings are not dramatic by nature. They are slow, procedural, and conducted largely in writing. Motions and responses and surreplies filed over weeks or months, judges reading documents in chambers, decisions arriving by mail. The hearing I was preparing for was not a trial. It was a formal evidentiary session, which meant both sides would present documentation and argument, witnesses could be called, and Judge Portis would issue a ruling on whether the codicil was valid, whether the original will should be set aside, and whether the estate should be redistributed accordingly. It also meant my mother would have to testify under oath. That was the part that mattered most. 6 days before the hearing, Douglas Whitmore filed a response to our motion. It was 47 pages. I read all of it in one sitting, at my desk, with a yellow highlighter and a red pen, the way I read every document that was going to matter. The response made 3 arguments. The first: the codicil was invalid because Gerald Bennett had lacked testamentary capacity at the time of signing, due to undisclosed cognitive decline. They had attached a declaration from a physician, not my father's primary doctor, but a geriatric specialist whose name I did not recognize, stating that Gerald had presented with symptoms consistent with early cognitive impairment during a consultation 8 months before his death. I read that page twice. Then I called Richard Pelletier and read it to him aloud. He was quiet for a moment. Then he said, "Did you know about any cognitive issues?" I said, "No, because there weren't any." I spoke to him 4 days before he died about a boundary dispute. He caught a drafting error in a survey I had reviewed and missed. Pelletier said, "We'll need his primary care physician's records." I said, "I'll get them." My father's doctor was a man named James Cho, a quiet internist in West Hartford who had treated my father for 16 years. I called his office that afternoon, explained the situation, and requested a full release of records. Dr. Cho called me back personally at 6:30 that evening. He said, "I want to be direct with you, Ms. Bennett. Your father was one of the sharpest patients I have ever had. At his last physical 8 weeks before he died, his cognitive screening was entirely normal. I documented it. I would be prepared to say so under oath." I thanked him. I asked his office to send everything to Pelletier by end of week. The second argument in Whitmore's response: the codicil had been executed under undue influence, specifically that I had used my position as a licensed attorney to pressure my elderly father into amending his estate plan in my favor. I read that paragraph 3 times. Then I set the document down and sat very still for a moment, the way I had learned to sit when something made me want to react visibly. Because visible reaction is information you are giving the other side for free. My father had walked into Hargrove and Pelletier alone. He had found them himself through a process Richard Pelletier had documented in their intake notes. He had not told me he was going. He had not consulted me about the codicil's contents. He had, in fact, specifically structured the entire arrangement so that I would not know about it until after he was gone, precisely to prevent anyone from making the argument that I had influenced him. He had anticipated this. He had closed this door before they thought to walk through it. I attached the Hargrove and Pelletier intake notes to our reply brief, along with Richard Pelletier's sworn declaration outlining the exact sequence of events surrounding the codicil's drafting. Gerald Bennett had initiated contact. Gerald Bennett had arrived unaccompanied. Gerald Bennett had provided his own instructions without input from any family member. Gerald Bennett had returned alone to sign. The third argument was the one I had been waiting for. Whitmore's response challenged Dr. Okafor's methodology, her credentials, and her conclusions. It attached a counter-declaration from a document examiner named Philip Crane, a man whose CV listed mostly insurance defense work, and who, had I noted, testified on behalf of the party claiming document authenticity in 11 of his last 14 engagements. His declaration was 8 pages. It described Dr. Okafor's methodology as non-standard and her conclusions as overreaching. It stated that the signature variations she had identified were within the range of natural variation for an aging signatory under stress. An aging signatory under stress. My father, signing his own will, would have been under stress. Therefore, the signature irregularities could be explained by stress. Therefore, the signature was valid. I sent the declaration to Dr. Okafor with a short note. "Please review and advise." She called me the next morning. Her voice had the particular flatness it got when she was being professionally restrained about something that did not deserve professional restraint. She said, "The counter-declaration describes my methodology as non-standard. I would like the opportunity to respond to that characterization in person, I said. You'll have it. 3 days before the hearing, something happened that I had not expected and had not planned for, and which turned out to be the most important development of the entire proceeding. Caleb made a mistake. It was not a dramatic mistake. It was the kind of mistake that cautious people make when they have been careful for a long time and then relax slightly because they believe the danger has crested. 4 months earlier, at the first settlement conference conducted by the probate court, a required mediation session that both parties attended, Caleb had been asked, as a matter of routine, to confirm his understanding of the original will's contents. He had confirmed it. Under oath, he had stated that to his knowledge, the will presented by Douglas Whitmore represented his father's final and complete testamentary intentions, and that he had no knowledge of any other estate planning documents executed by Gerald Bennett. That statement was in the transcript. Richard Pelletier had flagged it at the time. I had read it and said nothing and waited. Because if Caleb had helped draft or sign a forged will, which Dr. Okafor's report strongly implied required at minimum one additional party familiar with Gerald's signature, then his sworn statement at the settlement conference was not merely wrong. It was perjury, and the codicil, combined with the forensic report, combined with his sworn denial, meant that by the time we walked into Judge Portis's courtroom, Caleb Bennett had already handed us the most damaging piece of the case without realizing it. My father had written in his letter, "Patience is not the same as acceptance." He had also written, in the second to last paragraph, something I had not fully understood until that moment: the people who take shortcuts will always give themselves away. You just have to wait long enough to be there when they do. I packed my files the night before the hearing: the codicil, Dr. Okafor's report, Dr. Cho's records, the Hargrove and Pelletier intake documentation, Pelletier's declaration, the settlement conference transcript with Caleb's sworn statement, our response brief. I set everything in order on my kitchen table, the way my father had taught me to prepare for any meeting that mattered. Everything in sequence, nothing loose. Every document you need within reach before you need it. Then I went to bed at 10:30 and slept without difficulty for the first time in 4 months, because I had done the work. All of it, piece by piece, quietly, in the space my mother could not see. And tomorrow, Judge Harlan Portis was going to read a document my father had signed on a February afternoon with his full mind and his characteristic downward pressure and his lifelong instinct for making marks that held, and then he was going to look up. The Hartford Probate Court on Washington Street is not an imposing building. It does not have the granite columns and vaulted ceilings of the federal courthouse 2 blocks away. It is practical and pleasant and smells like recycled air and old carpet, and the courtrooms are smaller than television suggests, with low ceilings and wooden gallery benches that creak when you shift your weight. I had been inside twice before on client matters, and both times I had found the ordinariness of it oddly reassuring. The sense that serious things were decided here, without ceremony, by people who had done it many times before and would do it many times again. I arrived at 8:40. The hearing was at 9:30. Richard Pelletier was already in the hallway outside courtroom 4, talking quietly with his associate, a young woman named Priya, who had drafted 3 sections of our reply brief and had the focused, unhurried manner of someone who had prepared thoroughly and knew it. Richard shook my hand and asked how I had slept. I told him, well. He said that was good. We reviewed nothing. We had reviewed everything already. And reviewing it again in a courthouse hallway serves no purpose except to make you feel like you are doing something when the useful work is already done. At 9:10, my mother and Caleb arrived. She was in a charcoal suit with a silk blouse, her silver hair set precisely, her posture, the posture of a woman who had decided that composure was her argument and intended to make it from the moment she walked in the door. She was carrying a leather portfolio. She did not look at me when she came through the door. Caleb looked at me once, briefly, from across the hallway. His jaw was set. He looked the way he had looked in my conference room in Glastonbury, like a man who had convinced himself he was fine and needed everyone around him to confirm it. Douglas Whitmore was with them, along with a second attorney I did not recognize, a tall woman in her 50s who had the particular bearing of someone brought in for a specific purpose. I found out later her name was Karen Elliott, a litigation specialist Whitmore had retained when the forensic report arrived, and it became clear this was no longer a simple probate matter. We filed into the courtroom at 9:25, Judge Harlan Portis was already on the bench. He was 61. I knew from the court's public records, appointed to the probate bench 14 years ago after a career in estate litigation on the private side. He was a compact man with a broad, still face and reading glasses pushed up on his forehead. He had a reputation among the attorneys who practiced in his courtroom regularly for two things: thorough pre-hearing preparation and an acute intolerance for testimony that did not cohere. He had read our filings, all of them. I could tell by the way he looked at the documents on his bench before he spoke. Not scanning, not orienting himself, consulting. The look of a man who has already formed a view and is checking the detail against his memory of it. The hearing opened with procedural housekeeping. Both parties confirmed appearances. Judge Portis summarized the matter for the record. A petition to recognize a codicil dated February 19th and to set aside the previously submitted will on grounds of forgery. He stated this without editorial, in the same flat tone he might use to read a grocery list, and I noted that he did not use the word alleged before forgery, Karen Elliott. For the respondents, led off, she was smooth. I will give her that. She presented the capacity argument first, building carefully from the geriatric specialist's declaration. My father had shown signs, she said, of early cognitive decline. The codicil had been executed during a period of potential vulnerability. The petitioner, a licensed attorney and the sole beneficiary of the codicil, had both the motive and the professional capability to have influenced the process. She never said I had forged anything. She was too careful for that. She suggested a cloud. She asked the court to consider the cloud. Judge Portis listened without expression. He asked two questions. The first: had the respondents obtained the medical records of the attending physician of record, Dr. James Cho? Karen Elliott said they had not, as the declaration of the consulting specialist was sufficient to establish the issue. The second question: had the consulting specialist ever examined Gerald Bennett in person? Karen Elliott said he had not, as the consultation had been a records review. Judge Portis wrote something down. He nodded once, briefly, and said, "Continue." She moved to the undue influence argument. Richard Pelletier interjected, was permitted to respond briefly, and entered the Hargrove and Pelletier intake documentation into the record. Karen Elliott objected. Judge Portis overruled her without looking up. Then it was time for testimony. My mother took the stand. She was composed in the way that people who have rehearsed composure are composed. Slightly too still, slightly too measured, the responses arriving with a precision that felt prepared rather than recalled. She confirmed her name, her relationship to the deceased, her understanding of the estate. She confirmed that the will presented by Douglas Whitmore represented her husband's final intentions to her knowledge. She confirmed that she had no knowledge of any codicil or any contact between Gerald Bennett and Hargrove and Pelletier. Karen Elliott guided her through it cleanly. Then Richard Pelletier stood for cross-examination. He asked my mother to describe her husband's signature. She did, confidently, with specific details. He asked whether she was familiar with the documents Gerald had signed in the course of managing Bennett commercial properties over the years. She said she was generally familiar, yes. He asked whether she would characterize her husband as a man who signed documents carefully. She said, Gerald was meticulous about everything. Pelletier said, would you say his signature was consistent across documents over the years? She said, very much so. He always signed the same way. Pelletier said, thank you, and sat down. Judge Portis looked at his notes. Then he asked, in the same flat, unhurried tone he had used for everything else, whether the petitioner wished to offer additional documentation at this time. Pelletier said yes and nodded to me. I stood. I carried the folder to the clerk and handed her the documents in order. Dr. Okafor's full report, Dr. Cho's complete medical records with his sworn declaration attached, and the settlement conference transcript with Caleb's prior sworn statement highlighted on page 7. The clerk handed them to Judge Portis. The courtroom was quiet in the specific way that courtrooms get quiet when something has just changed, and everyone in the room knows it except possibly the people it is about to change for. Judge Portis read. He read for 6 minutes. I know because I watched the clock on the wall above the gallery. A plain institutional clock, the kind with a red second hand, and I watched that second hand move through 6 full rotations while my mother sat with her hands folded on the witness stand, and Caleb sat at the respondent's table, and Douglas Whitmore made a small note on his legal pad, and Karen Elliott looked at a fixed point on the wall with the expression of someone recalculating. Judge Portis set the documents down. He looked at his bench for a long moment. Then he took his reading glasses off his forehead, put them on, and looked at my mother. He said, "Mrs. Bennet, you testified that your husband's signature was consistent across documents over the years, and that he was meticulous about how he signed." My mother said, "That's correct," he said. "I have before me a forensic document examination report prepared by Dr. Sandra Okafor, whose curriculum vitae reflects 23 years of practice and testimony in federal and state courts." Dr. Okafor's report concludes, "To a reasonable degree of professional certainty, that the signature on the will you presented through counsel is not consistent with authenticated signatures of Gerald Bennett across 11 reference documents." He paused. My mother's hands, folded on the railing of the witness stand, did not move. But I saw something shift in her face, a small tightening around the eyes, a compression at the corners of her mouth. Judge Portis said, "I would ask you to consider your answer carefully, Mrs. Bennet. I am going to ask you to tell this court, again, under oath, whether you have any knowledge of how the signature on that document came to be on that document." The courtroom was very still. My mother opened her mouth, closed it, opened it again. For the first time in 32 years, I watched Diane Bennett not know what to say. She said, Gerald signed that document. I was present." Judge Portis let the silence sit for a full 3 seconds. Then, slowly, deliberately, he turned his eyes away from my mother and looked at me. I had imagined this moment, not obsessively. I am not a person who rehearses triumph the way some people do, running the reel forward to the part where everything resolves, because I have found that imagining the win too clearly makes you brittle when the actual moment arrives differently than you pictured. But in the quieter parts of those 4 months, in the early mornings before my alarm, and the late nights after I closed my files, I had let myself think briefly about what it might feel like when the balance shifted. I had imagined relief. I had imagined vindication, whatever that actually feels like in the body. I had not imagined how quiet it would be. Judge Portis looked at me over his reading glasses and said, "Ms. Bennet, you are the petitioner in this matter, and the named beneficiary of the codicil submitted for recognition. Do you wish to address the court?" I stood. I said, "Yes, Your Honor." I had prepared remarks. 2 pages, single-spaced, in a folder on the table in front of me. I did not open the folder. I said, "Your Honor. The codicil executed by Gerald Bennett on February 19th at the offices of Hargrove and Pelletier was prepared independently, at my father's sole initiation, without my knowledge or participation. The documentation in evidence reflects the full sequence of events surrounding its creation. I would ask the court to recognize it as his final testamentary expression and to act accordingly." I sat down. Richard Pelletier, beside me, did not move, but I felt him exhale very slightly, the way people do when something lands exactly where it was aimed. Judge Portis looked at the documents on his bench again. He looked at Karen Elliott. He said, "Counselor, your client testified under oath moments ago that she was present when her husband signed the document you submitted as the operative will. The forensic report in evidence concludes that signature is not Gerald Bennett's. Those 2 facts cannot both be true. I want you to understand that I am noting this for the record." Karen Elliott said, "Your Honor, we would request an opportunity to respond to the forensic findings with supplemental." Judge Portis said, "The time for supplemental submissions was in your response brief. You submitted a counter-declaration. I have read it. I found it unpersuasive." He looked at her steadily. "I also have before me a transcript from the settlement conference held in this matter on August 14th, in which Caleb Bennett, under oath, stated that he had no knowledge of any estate planning documents executed by Gerald Bennett beyond the will submitted through counsel. That statement, in light of the forensic findings now in evidence, presents a concern that goes beyond the scope of this proceeding." He turned to look at Caleb. Caleb had gone the color of old concrete. He was sitting very still at the respondent's table, with his hands flat on the surface in front of him, and his face had the particular quality of a face that has stopped performing and has nothing underneath the performance to fall back on. His mouth was slightly open. He looked, for the first time in the 38 years I had known him, like someone who did not know what came next. Judge Portis said, "Mr. Bennett, you are represented by counsel, and I would advise you to consult with them before saying anything further in this proceeding." Douglas Whitmore leaned toward Caleb and said something in a low voice. Caleb did not respond. He was looking at the table. My mother was still on the witness stand. She had not been excused. Judge Portis had not excused her because there was nothing to excuse her to. The proceeding was still active. She was still under oath, and the question he had asked her remained, technically, unanswered. She was sitting with her hands in her lap now, the leather portfolio closed on the railing in front of her, and she was looking at a point approximately 2 feet above Judge Portis's head, with the expression of a woman who has decided that if she does not acknowledge what is happening, it is not happening. I had seen that expression before. At Easter dinners when someone said something she did not want to engage with. At my father's retirement party, when a business associate praised me in terms that were slightly too effusive for her comfort. The expression that meant she was recalibrating, somewhere behind her eyes, in the place where she filed the slights and let them collect interest. Only there was nothing to recalibrate toward this time. Judge Portis said, "Mrs. Bennet, I want to give you one more opportunity. Is there anything you would like to add to your testimony before I make a ruling?" My mother's gaze came down from the middle distance. She looked at the judge, she looked at Karen Elliott. Karen Elliott gave a very small, very deliberate shake of her head. My mother said no. Judge Portis nodded. He said, "This court finds the codicil dated February 19th, executed at the offices of Hargrove and Pelletier, LLP, to be a valid testamentary instrument under Connecticut law. The document was properly executed, witnessed, and notarized. The petitioner has established by clear and convincing evidence that the codicil reflects Gerald Bennett's final testamentary intentions. The previously submitted will is hereby set aside in all provisions that conflict with the codicil." He paused. The red second hand on the clock above the gallery moved through half a rotation. He said, "Furthermore, this court is referring the matter of the signature on the previously submitted will to the Office of the Chief State's Attorney for investigation. This referral encompasses the testimony given in this proceeding and the sworn statement from the settlement conference of August 14th. He looked at Caleb again, briefly. "Both documents will be transmitted this afternoon." He looked at Douglas Whitmore. "The Connecticut Statewide Grievance Committee has already received a separate complaint from the petitioner's counsel regarding the submission of this document by an officer of the court. I would note that the evidence before me today will be included in this court's own communication to the committee." Douglas Whitmore had stopped writing. Judge Portis set down his pen and looked at the room. He said, "We are adjourned." The gavel came down once, clean and final, like a period at the end of a sentence that had been 40 years in the making. What happened next took approximately 4 minutes. And I watched it the way you watch something you have been told is coming, but still cannot quite process when it arrives. 2 officers from the court's security detail moved toward the respondent's table. I had known this was possible. Pelletier had told me the state's attorney's office had been briefed on the potential perjury exposure and had requested a hold if the referral was made. I had known it intellectually. Watching it was different. One officer spoke to Caleb in a low voice. Caleb stood up. His face had moved past the concrete color into something that had no color at all. He said something I could not hear. The officer responded. Caleb looked at my mother. My mother was being helped down from the witness stand by the second officer. She was not resisting. She was not speaking. She was moving with the careful precision of a woman whose body is doing what it is told, while the rest of her is somewhere else entirely, still recalibrating, still looking for the angle, still running the numbers on a situation that no longer had an angle or numbers that could save her. She passed within 6 feet of me on her way out of the courtroom. She did not look at me. I did not say anything. There was nothing to say that the last 4 months had not already said more completely, in 41 pages of forensic analysis and a 4-page codicil signed by a man who had trusted his daughter to read the fine print. Caleb passed a moment later, flanked by the officer. He looked at me once. I looked back at him. I did not look away first. Richard Pelletier put his hand briefly on my shoulder and said, "Whitney, just my name, nothing else needed." The courtroom emptied slowly. Gallery observers, the court reporter, Karen Elliott, gathering her files with the quiet efficiency of a woman who has lost and intends to bill for the experience anyway. Douglas Whitmore left without looking at anyone. I stayed in my seat. I sat in courtroom 4 of the Hartford Probate Court for 9 minutes after the last person left, in the recycled air and the fluorescent light and the particular stillness of a room where something consequential has just finished. I looked at the bench where Judge Portis had sat. I looked at the witness stand where my mother had told her last lie about my father's signature. I looked at the clock on the wall. Then I picked up my folder, the one with the 2 pages of prepared remarks I had not opened, and I put it in my bag. I walked out of the courthouse into the October afternoon. The air outside was cold and smelled like fallen leaves and exhaust, and the river somewhere nearby. And the sun was low and flat, and the whole city looked the way cities look in early fall. Slightly more itself than usual, the light doing something specific to the brick and the concrete that it only does in October. I stood on the courthouse steps, and I called no one. I took out my phone and put it back in my bag. I walked 2 blocks to Asylum Street. I stood on the sidewalk across from the building and looked up at it. 6 stories, brick facade, the retail awnings on the ground floor, the office windows above catching the afternoon light, the corner of the roof where my father had pointed once and said he wanted to eventually put a small terrace up there. Something people could use, my building. His voice was very clear in my head in that moment, clearer than it had been since March. And I stood on the sidewalk in the October light and let it be clear, and I did not try to do anything with it except hear it. You've got a good eye, Whit. Don't let anyone convince you otherwise. I stood there for a long time. The criminal proceedings took 8 months. I will not walk you through every filing, every continuance, every motion and countermotion, because the legal machinery of a criminal case is slow and procedural, and the details matter enormously to the people inside it and very little to anyone watching from outside. What I will tell you is what happened, and what it cost, and what it did not. Diane Bennett and Caleb Bennett were charged in November with forgery, in the first degree, filing a false instrument, and perjury. Caleb faced an additional count of making a false statement under oath at the settlement conference. Douglas Whitmore was referred to the statewide grievance committee and ultimately surrendered his license to practice law in Connecticut in a consent agreement that avoided a formal hearing. The geriatric specialist who had signed the capacity declaration without ever examining my father was reported to his licensing board. I do not know what happened to him after that. I did not follow it. My mother hired a criminal defense attorney. A good one. Expensive. Someone whose name I recognized from the Hartford legal community. She maintained her position for 4 months. Then, in late February, faced with Dr. Okafor's testimony at a pretrial hearing and the accumulated weight of everything Pelletier and I had built, she accepted a plea agreement. She pled guilty to forgery in the second degree and filing a false instrument. She received a suspended sentence of 18 months, 3 years of probation, and a fine of $42,000. She was required to make full restitution to the estate for all funds disbursed from Gerald Bennett's accounts. In the 8 months between his death and the court's ruling, Caleb pled guilty to perjury and forgery. He received the same suspended sentence, the same probation, and lost his real estate license. The medical device sales job ended 2 weeks after the plea was entered. I heard through Aunt Roberta, who kept me carefully informed throughout, that he had moved to a rental apartment in New Britain and was working in some capacity I did not inquire further about. My mother still lives on Farmington Avenue. The codicil's life estate provision means she can remain there until she chooses to leave or until she dies. I did not contest this. It was what my father had wanted, and my father's intentions were the only thing that had mattered to me since the day I sat in a parking lot in Glastonbury with my phone in both hands and listened to Richard Pelletier tell me that Gerald Bennett had trusted me to find him. She and I have not spoken since the day she passed 6 feet from me in courtroom 4 without looking at me. I do not expect that to change. I have made my peace with it in the way you make peace with a thing that was always going to be what it was, not by pretending it doesn't hurt, but by deciding that the hurt is not the most important thing about the story. The estate was fully transferred to me in the spring. The investment accounts, the 30% my father had designated, arrived first. $423,000, which I moved immediately into a separate account I opened the same afternoon. The commercial portfolio took longer, as transfers of that size always do, but by April the 11 properties were in my name, held in the trust my father had specified, administered by an independent fiduciary I selected after interviewing 4 candidates. The building on Asylum Street I handled personally. I walked through every floor on the first Tuesday in May, alone, with a legal pad and a flashlight for the utility spaces, the way my father had taught me to inspect a property. Not from a distance, not from a report, but in person, with your own eyes, room by room, paying attention to what the building is telling you, if you are willing to listen. The retail leases were solid. The office tenants above were a mix of small professional firms and one nonprofit, all current, all well-maintained. The building was in better condition than I had expected, considering my mother had been operating it for 8 months without, as far as I could tell, any particular investment in its upkeep. The corner of the roof, where my father had pointed and said he wanted a terrace someday, was structurally sound. I got a contractor's assessment 2 weeks later. The terrace was feasible. I approved the plans in June. I thought about what he had said that afternoon, about grandchildren in offices. I am 32 years old. I do not have children yet, but I have time, and I have a building, and I have a father who believed in both of those things, enough to sign his name to them with his full weight behind it. On a February afternoon, when he already knew he was running out of time, 8 months after the ruling, on a Tuesday morning in early November, I parked on Asylum Street and sat in my car for a moment before going in. The building looked the same from the outside as it always had: brick, 6 stories, the retail awnings, the office windows. It was the same building my father had bought distressed in 2003 and spent 4 years stabilizing, while people who knew better told him he was overextended. The same building he had walked me through on a Saturday afternoon and talked about grandchildren and patience and the things worth holding on to. The only thing different was the small bronze plate beside the front entrance that the building management company had installed at my request the previous week. It read, Bennett Commercial Properties, Asylum Street, Est, 2003, GMB. I sat in the car and looked at it for a moment, then I picked up my bag, got out of the car, and went to work. I want to tell you what I learned from all of this, because I think it matters, and I think it matters especially if you are someone who has ever been in a room where the people who were supposed to choose you chose something else instead. Silence is not the same as weakness. I spent 4 months being quiet in a way that my mother read as defeat, and the whole time I was building something she could not see and could not dismantle and could not charm her way around. Patience is a form of strength that looks like nothing from the outside and feels, on the inside, like holding a very heavy thing very still for a very long time. It is not comfortable, but it works. And here is the other thing. The one my father knew and tried to tell me in 100 small ways over 32 years, and finally said plainly in 2 pages of handwriting in a letter I keep in a locked drawer at home. The people who love you will find a way to say so, even when they are running out of time, even when they cannot say it out loud in the room where it would have mattered most. They will find a way to put it somewhere you can find it. You just have to be willing to look. If this story reached something in you, if you have ever been written out of a room you deserved to be in, or held quiet when you wanted to fight, or trusted something you could not yet prove, I want to hear from you. Leave a comment below and tell me where you are watching from. Tell me what you are holding on to, and if you are new here, please subscribe. There are more stories, and every one of them is about the same thing: what people are capable of, and what they are worth when it finally matters.